Just a moment, please. Okay, please begin.
Good morning. If it pleases the court, Attorney Bruce Block. I'm here on behalf of defendant appellate Todd Van Doorne. Over at counsel table is Attorney Jeff Arnson. He is attorney for appellant Mr. Frederick. I'm here today to ask several things. Asking you to rule that the knock and talk that was employed in this case, the procedure that was employed in this case, was unconstitutional, as it violated the Fourth Amendment. Both the trial court and the Court of Appeals reached the conclusion somehow that there wasn't a search in this case, and that also the knock and talk somehow complied with the implied license that would be extended to private citizens. In my opinion and that of my colleague, this published precedential opinion is troubling. The legal reasoning of the majority was flawed and frankly puts Michigan Fourth Amendment jurisprudence out of step with the rest of the country. Particularly how knock and talks are to be analyzed post-Florida v. Jardines. This court needs to accept our application for leave, but more importantly, it needs to provide lower courts with a framework. How do you analyze knock and talks post-Florida v. Jardines? Jardines, I think, set forth a very basic standard. What the late Justice Scalia wrote, he thought was a simple one, which is when the government obtains information by physically intruding on a person's houses, papers, or effects, a search within the original meaning of the Fourth Amendment has, quote, undoubtedly occurred. I don't think there's any dispute that the police are on the curtilage. They're at the front door of the houses of Messrs. Frederick and Van Doorne. Reading Jardines, that's a search. So then the only question becomes, was there an exception to the warrant requirement? Because it's not disputed, there was no warrant in this case. Police testified at the evidentiary hearing they had probable cause for a warrant, but determined or decided not to get one. So you have police, they're at the front door, there's no warrant. So then the only exception I think that could apply here that has been briefed and argued is, of course, the knock and talk exception, which rests on societal rules, habits, we've all come to know as the implied license test. I would refine it even further and say it's a simple test, really. I think we all know what this test is. If we're baking a cake and it's 4 in the morning, do we call our neighbor and wake them up, or go over to their house and bang on their door or ring their doorbell and say, hey, can I borrow a little flour? No, obviously not. Do we go over there and do we wake them and rouse them?
So, counsel, even if you're right, Jones says you need two things. You need a trespass and a searching for something or someone. And here your argument is it's a trespass because at 4 in the morning, you're not licensed by the habits of the country to enter somebody's curtilage. That's your argument. Therefore, it's a trespass. But I've still got this other problem, which is knocking on the door and asking for consent, consent to search the house. Is that itself a looking for something or someone?
Based on...
Because trespass alone, otherwise you're arguing trespass alone is a search. And that can't be right, right? Like if a police officer cuts off a corner, he's rounding the corner, he's on the sidewalk, he comes up to the corner and he cuts across my property, he's trespassed. But if he's not looking for something, he hasn't searched. Right? The blindfolded police officer who cuts across my property is trespass, but certainly hasn't searched. So what I'm looking for is a search.
And I guess I hear the argument. I hear what you're saying. I don't read Jones and Jardines stating that.
Well, Jones says when you put the GPS device under the car, that is itself a trespass. But Jones also says not every trespass is a search. It had to be that the critical thing in Jones was you put the GPS device under the car, that's a trespass, and you're trying to locate information about the suspect and his whereabouts.
Correct.
Trespass facilitates the search.
You need both. I mean, Jones says it. You need a trespass and a looking for someone. So even if we conclude this is a trespass, I still need the looking for someone. Is this a looking for someone?
Looking for someone or looking for something?
Either would do, according to Jones.
Because I think clearly, well, obviously, I think it's going to be argued that it wasn't, but...
Wait, that's why I'm interested in your argument.
Yeah, what is your argument?
Search.
She's asking you to tell us what the
Yeah.
connective tissue is here.
Yeah. It is, the trespass that you're referring to, I don't know, a police officer walks on a corner of the lot not realizing that he's on your property, I think can be...
No, I think he realizes he's on my property. He just finds it more convenient to cut across my property. So he has trespassed. I could sue him for trespass, but I can't. There's no Fourth Amendment violation.
Fourth Amendment search. She's just asking you to supply why you believe there's connective tissue that vitiates this search and makes it an illegal search or seizure.
I think
when there was consent.
when you look at the totality of the circumstances, which the Court of Appeals did not look at when evaluating on remand.
Let's
I think you're
make it
moving
easy.
to, and I think you moved it too. Perhaps you might say, in response to Justice Larson's question, they were searching for my client.
Might say
that's
that.
a search.
Yeah.
That might be one answer.
Well, I think that why would you go to their house? I guess that, to me that would be a given that they're searching for my client.
Okay, well, that would be an answer.
That's an answer.
And I believe they were also searching
For the
with
butter.
their deceased marijuana butter. Yes.
Right. But,
Now,
so yes, gotcha.
But
So
they
now-
didn't intend, there's no allegation here. Well, there might be an allegation here, but there's testimony to the contrary here, that if your client hadn't shown up at the door, that they would have gone ahead and gone into the house looking for the butter. Instead, the testimony of the police officers is they would have gone back to their car and figured out what plan B was going to be, go get a warrant or whatever.
I'm not sure I understand the question as far
Well,
as
it
how
can't
that...
be a search for the butter if what they were doing, their purpose for being on the doorstep was simply to ask your client for consent to go into the house and look for the butter.
And that would get back to the issue, one of the issues you wanted us to brief, which was this idea of did they objectively intend to search? And we would argue that they did, based on the number of officers, the number of cars, bringing in a superior officer, lieutenant, the time of day. You have to recall that they had been to various other houses prior to coming to Mr. Frederick's house and Mr. Van Doorne's house. They started at 10:30 the night before and had gone through, if you will, the daisy chain or the list of different houses. By the time they got to my client's house, he was the last one on the list. They knew exactly what had happened, what had transpired. And in fact, my client testified at the evidentiary hearing that the first words out of their mouth was, "We're here about the butter."
Yeah, but we're here about the butter. Can we come in?
yeah.
Yes.
And if he said no, then what? To
If he
search?
said no, then they would have had to leave. But I guess what I come back to is, are we going to condone this kind of behavior?
We're only going to condone it if the consent can be analyzed separately from the search. So tell us about that. I think, tell us about the consent and the attenuation between what you think was an improper Fourth Amendment search for your client. I'm just going to fill that in. And the consent. Is there attenuation such that we should forget about the search?
I don't believe that there was any attenuation.
Why is attenuation
I think it's
the concept of the we have to seize on?
The attenuation.
Let's, for the sake of my question, let's assume that they are trespassing. They don't fit within the knock and talk exception. So they are inappropriately on your client's porch. And now they're there and they're saying, may we come in and search for the marijuana butter? Two outcomes. One, he says, yes. They come in, search for the butter, they find it, and they arrest him. The other says, I think as a police officer, I know my rights. You don't have a search warrant. Bye-bye. So I'm trying to figure out why the separate inquiry about whether they can come in to search is
cures the previous violation. Why doesn't his consent cure the previous Fourth Amendment violation?
I would argue that it doesn't, and I do want to give time to my colleague here, so I probably will let him answer this one and flesh it out a little more.
Okay.
But I would suggest that this was not voluntary consent. This wasn't freely given for a number of factors, which, Mr. Arnson, you get to answer.
Well, can I just summarize what no, please come up here.
Good morning.
Can I just summarize? I'd be interested not only in knowing whether you think there was attenuation, but also whether you think there was something inherent in the inappropriate time that the police came to the home that suggests some kind of implicit coercion.
Yes, I do want to address that question.
Counsel, good morning. We just need you to state your name for the record, please.
Thank you. Jeff Arnson, on behalf of the defendant appellant, Michael Frederick. The question whether there was a search or not, I did want to get back to, or start with Justice Larson's question first. We believe that there was a search because they're on constitutionally protected property and they do not have an implied license to be there. We have argued that.
Okay.
If you look at the Jardine's opinion.
Yeah, but that would also be true if the police officer cut across my property blindfolded. He would now be on constitutionally protected property. I suppose maybe it's not sufficiently curtilage, but let's assume I live in a row house that is, where my front porch basically ends at the sidewalk, okay? And so he cuts across my front porch in order to make his way across. But he's blindfolded, so he has trespassed, but he didn't search.
I believe it's a factually intensive question that would need to be analyzed. And in Jardine's, the court
What we're trying to figure out is where you have a trespass followed by a search where the intermediary event is a request to do the search. And why those two events, the trespass and the subsequent consented to search, is unconstitutional.
The majority of these cases, as the court is aware, involve police engaging in a knock and talk and actually doing some sort of a search or some clandestine activity. And in this case, there was a knock and talk that the police said they engaged in. They went to the front door and they actually knocked. What Jardine's, in the footnote 3, it says it's not the dog that's the issue here. You have to look at the police activity and you have to look at reasonableness. Under the Fourth Amendment, general reasonableness is an inquiry.
So it would be unreasonable for them to ask for consent.
At this time, based upon the implied license of...
No, I'll concede they're trespassing. So the knock and talk predicate is missing. They're trespassing and they're knocking on the door and saying, can we come in and search for the illegal marijuana butter?
Correct. And if consented to, does that result in an unreasonable search under the Fourth Amendment? If the consent is voluntary, no. If the consent is not voluntary, then I would argue.
So you lose if we conclude that your client's consent was voluntary.
I read Jardine's to say that a search in this case occurred. And I might be...
That's not the question. There are all sorts of cases, all sorts of Fourth Amendment doctrine from courts around the country where there's a search, an illegal one, and yet we don't suppress the fruits of that search because there's been some attenuation, some intervening circumstances that cause us to forgive the earlier Fourth Amendment violation. In your case, that might be this consent. Why is the consent that your clients gave not, why should the subsequent search still be, why should we still suppress the fruits given that consent?
And I would agree with that analysis.
I didn't give you an analysis, I asked you a question.
Well, in the analysis in that question, the question, and we briefed this about that we believe that the consent was obtained coercively here.
I know, but I'm not interested in coercion. I'm interested in attenuation. Is there attenuation such that the consent that your clients, if we believe voluntarily gave, should we still hold the police responsible because of the Fourth Amendment violation because there was no attenuation?
We believe so, because in the facts of this case, the superior officers were brought in, the time of the night, all these things.
That goes to coercion. She's asking a different question.
So attenuation generally means that there was like a big gap in time between the or some other intervening circumstance between the time that the Fourth Amendment violation occurred and the search or the recovery of the fruits, such that even though it was an illegal search and it uncovered this damning evidence, we can disconnect those two things. So what we're wondering is, you want us not to disconnect those things. You want to say the search, the illegal search in your mind, produced the evidence and there's no attenuation between the two. Why is that true?
Because the facts in this case, in both of these cases, are such that after contact was made at the front door, police went inside immediately and consent was obtained very quickly, and we believe
so.
You're
saying no matter whether the consent was voluntary or not, that was an irrelevancy for Fourth Amendment search purposes.
I believe that whether or not consent was obtained voluntarily is impactful here.
You think it's critical, actually. So there's two different questions. Justice McCormick was asking you about attenuation. Is there a break in the chain?
And
I think Justice Young, and you say no.
We say no.
Justice Young is asking you about whether or not, if your client freely consented without duress, your client said, I got nothing to hide, guys, come on in, would that still be a Fourth Amendment violation? Does everything in this case hinge on whether we determine that your clients freely consented or whether they were coerced? Is that the linchpin?
That is the linchpin to this case. However, I do believe that overall with jurisprudence, this court needs to take this case so we can give some type of guidance to lower courts.
Great. So let me ask the follow-up question. The follow-up question is, in the next case, let's say we say, yep, your client did not validly consent. They were coerced, and therefore that consent is no good. But in the next case, we have a 4 o'clock knock and talk, and the owner of the house opens the door and says, yeah, come on in. I want to allow you to search my property, and makes no claim of duress or coercion. Is that okay?
I would argue no.
Why?
Because I believe that, well, the Fourth Amendment, any type of Fourth Amendment, if the police violated the Fourth Amendment, in that case, or in this case, secondarily, validly contained consent would vitiate that and take away that. So I believe you're correct. If the consent is not an issue in future cases, a 4 a.m. knock and talk or a 5:30 knock and talk could be appropriate.
So to put it in Justice McCormick's attenuation, I guess you could say a voluntarily offered consent to search attenuates the antecedent trespass. Is that correct?
Always.
I believe that's the accepted law. I mean, if any type of Fourth Amendment violation, if there's consent, validly obtained consent afterwards, it would attenuate that.
So the police can show up at 3 o'clock in the morning, knock on anybody's door, say, hey, can we come in and search your home? Your answer is, as long as the homeowner says, sure, come on in, guys, that's totally fine.
Right after they ask.
Under the
No
current
attenuation whatsoever.
Under the current analysis of the law, I believe that's true. However, I believe that we need this state
Even
needs
though they
guidance.
have trespassed. Well, because, or maybe you're saying 4 o'clock in the morning doesn't make it a trespass. Because here is the concern. If you can trespass and then get consent, why can't they just come into my living room
And sit there.
and say, hey, I'd like to search the rest of your home? It's a trespass.
You have a nice living room. I would like to go through that safe over there.
I believe that the context of the facts is important. What is the level of the trespass? What is going on in that case?
Okay.
I thought you were saying, maybe I'm misinterpreting it too, I thought you were saying initially that whatever the attenuating effect of consent in the context of an otherwise questionable search, there can be no such attenuation in the context of a trespass because that trespass casts some doubt upon the genuine voluntariness of that consent. Is that correct?
I would say that the
Or is that not
level
correct?
of the violation does, in the facts of the case, lead to the question of whether or not the voluntariness of the consent is valid or not.
So am I summarizing your position rightly or wrongly?
I believe that you're summarizing it correctly.
Okay, so, but some have misinterpreted what you've said. Is that fair to say too?
I'm a little unsure.
So are we.
It's possible. We do that. You
I,
can say yes. It's okay.
Yeah.
are there any other questions?
No.
Thank you.
You can escape.
Thank you very much.
Good morning. May it please the Court. James Benison with the Kent County Prosecutor's Office on behalf of the people of the state of Michigan. Directing my comments to some of the questions the Court has raised, the defense has, I think that Justice Larson correctly points out, even if there was a trespass, it's not a search. If I came up to you and I somehow got into the back hallway and said, hey, can you show me your office? I've never been back here. Can I take a look? I'm not legally back there because I don't have permission to be in the back hallway. If you say, go ahead and take a look at my office, I have not committed a seizure, I have not conducted a search prior to you saying, sure, come on back. There cannot be a Fourth Amendment violation simply based on the fact of I'm asking a question. And I also dispute the contention of defense that Jardines defines the scope of a knock and talk. Jardines was not a knock and talk case because there was no knocking and there was no talking. It was not. That was the argument put forth by the authorities in Florida to say, hey, we can do this because we could have gone up to the door to knock and talk, so we can go up to do a search. And the Supreme Court said, no, you cannot search the curtilage of a home without a warrant or an exception. That's the rule that they came up with because that's what that case was about. To try to take language where they said a knock and talk is still fine and say that that case somehow changes the dynamics of a knock and talk doesn't make sense on the facts of Jardines, and it doesn't make sense to apply it to the facts here. Simply being on the curtilage is not a search, and I would argue, as I did, that it's not even a trespass because there are multiple circumstances where a person would be okay with a person coming to the door at 4 o'clock in the morning. Trespass is defined by Michigan law. It's not defined by the common law anymore. It's defined by statute. No one would be found.
Do you really contend that having 7 armed and vested officers arrive at your home at 4 a.m. is a normative thing we customarily expect and pound on your door for 5 minutes? Is that your argument?
Since none of those facts are what the trial court found, I don't have to agree to that.
Okay, what
There
are
was
the-
not 7 at the door.
Okay.
How many at the door?
The trial court said 2. The Court of Appeals said 3 or 4, depending on which particular defendant you're referring to.
Okay. 2 officers
and
pounding at the door at 4 a.m.
And they weren't for 5
Are we good
minutes.
there?
They were there for long enough for a person who was
5
inside to come to the door. It was not for, it was, I believe the trial court's factual findings were for a few minutes, enough time for somebody to get to the door.
Okay.
And
not
do I
making
think
much
it's
headway.
normative for somebody to do that all the time? No.
Ever.
Yes.
Except in an emergency. What neighborhood do you
Would
live
the
in?
reasonable Girl Scout do that? Isn't that kind of the test?
No. If the test is a reasonable Girl Scout, then I think here's the problem with the reasonable Girl Scout test. And it's one of the examples that I included in my brief. Police notice a home invasion has occurred. There are footprints in the snow to another house.
That's an emergency. That's a different exception.
Is it an emergency? They can sit around the house. It's 5 o'clock in the morning. It'll be 2 hours, 3 hours before normal daylight hours where a Girl Scout might come to the door. They can sit in the house and wait until it's daylight hours, or maybe they can get a warrant. But instead they go to the door and knock.
That's not a knock, and I think that's a different exception, isn't it?
They're going to go to the door. They expect that the person inside the house is the person who committed the home invasion, but it might be that person did another home invasion and the people inside the house don't know the person's there. Law enforcement cannot be that handicapped to only be allowed to go to a door at the same time a Girl Scout would go to the door.
There's an antecedent fact here that they have a reason to believe some crime has occurred and a criminal's at escape. They came to both of these officers' homes in search of their stuff. They wanted what they thought was illegal marijuana butter. They didn't think that somebody had run into those homes and might escape who had committed a crime. That's an inapposite.
But they did think that there's a chance that the evidence could be destroyed if they didn't follow through on the investigation before the trail went cold. That's what they, I mean, there's no contention here that whether it's a robbery, a home invasion, a drunk driving.
Why did they think that? Because they thought that the occupants of the house had been tipped off somehow?
No, I believe the testimony was with the phone tree, I believe was the words of one of the officers, you know that people can get informed, so that's why you have a reason to continue the investigation and not stop it at 8 p.m. or whatever time until the next morning, whatever time this court would set.
Or you get a warrant.
So these were not particularized facts about why they feared that in this case. You're saying in general this should be an exception to the knock and talk rules because in any case where they're searching for drugs, it's possible that somebody could get tipped off. So we should just have a different rule for drug searches.
No, because the same thing could be true about a stolen phone.
So you're talking about a generic rule for any...
For police.
What I am saying is that there is the defense commented that there was, and the dissent said there was no reason for the police to have done this when they did. There was a reason. There was a legitimate law enforcement concern to prevent the trail from getting cold and evidence from being destroyed.
What was the
But in
explanation
general,
for
not
getting a search?
particularized to this.
I'm sorry, what?
Yeah.
I heard since both were talking, I'm not sure.
Yeah, they have a particularized reason to believe there might be a crime. That's why you go get a search warrant. Why didn't they get a search warrant? What was the record on that?
The record on that was multiple reasons. One, they wanted to, if there was a valid explanation for it, to not have it be in the media. And two, it's faster and more convenient, and the Supreme Court in Kentucky versus King said that was fine.
Seizure is always much more
It's more
convenient.
convenient.
But the U.S. Supreme Court in Kentucky versus King said that's a perfectly legitimate reason to not get a warrant, and it was an 8-1 decision that said you don't need to get a search warrant just because you have probable cause. So unless this court wants to interpret the Fourth Amendment...
But you still have to come within the confines of the Fourth Amendment.
You still have to have an exception, don't you?
I mean, it can't be. I would like to it's always more convenient not to get a search warrant, and therefore I can violate the Fourth Amendment. That's not your
There
argument.
is no Fourth Amendment violation when you simply go to the door and ask to speak to the person.
Right, we have to find first that there is no Fourth Amendment violation.
And just assume we disagree with you, because I thought your argument was, maybe I misunderstood your brief, I thought your argument was the argument that the defense counsel have made on your behalf quite well today, which was, no offense, but that consent the consent here was valid, and therefore, it doesn't matter if there was a trespass. I thought that was your argument.
That is one of my arguments.
Oh, I thought that was your main argument.
Okay, but then,
No,
but,
apparently
but
not.
let's talk about that, because you know I'm worried about this. We talked about this last time.
No, it was a different county.
Oh, it wasn't
But I-
you.
I did
Not the
think-
shower
You're
thing.
aware.
I did watch
Please,
the
not
argument.
that.
We know what she's afraid of, yeah.
Yes,
Right.
the going into the house while you're taking a shower.
Yes.
And
Right.
This is
And
the thing.
You say, all I want to do is talk to the lady of the house.
I-
I hear the water is running. I'd like to talk to her. She must be in the shower. I'll just go up and ask her whether I can search the house. And if I say yes, you've done nothing wrong.
First, by having gone into the house, the U.S. Supreme Court in California versus Serralo did make clear that the curtilage is different than inside the house.
Well, Justice
Really?
Scalia doesn't say that in Hardiness.
Yeah.
He says the ancient rules of the close, right? He
That the
says
air-
curtilage equals house.
That the area is within the curtilage does not itself bar all police observation is from California versus Serralo.
That's why you can go knock.
Correct. That's why you can go up to the front door of the house
As long
and
as you
knock.
comply with the habits of the country.
And you cannot go past the front door. That is a different kind of violation. That is now an illegal entry. And I think that that does change the
So
dynamics.
an illegal entry in the house vitiates subsequent consent.
I
Not the
would be
illegal entry
comfortable
on the
saying that,
curtilage.
yes.
Okay, so
And
illegal
why
entry on the
doesn't,
curtilage does.
why is that true? Why does the illegal entry into the house, okay, I see this, vitiates consent,
Because under the totality
but
of the circumstances.
illegal entry onto the curtilage does not vitiate consent?
Because it's
Why?
not an illegal entry. It's at most a trespass. And again, under Michigan law for trespass.
What's the difference? It's a trespass if you break into my house, it's a trespass if
We
you
have
come
different
onto my
statutes.
porch.
Is it because it's more flagrant? Is that what you're trying to say?
It's part of what I'm trying to say. The legislature and has described an entry into a home as being of a different character.
Yeah, but it can't
than a
be that
trespass on land.
that
Trespass
people.
is a 30-day misdemeanor generally, or
Wait, is your argument that the constitutional confines of the Fourth Amendment depend on the vagaries of state criminal trespass law?
no, but the Jones decision talked about trespass, and trespass is defined by state law.
Well, it's certainly defined by state law for purposes of arresting people and putting them in jail for violating the crime of trespass in Michigan.
And tort
What I'm
liability.
asking you is, do the various state laws on trespass, whatever they might be, inform and dictate the boundaries of the Fourth Amendment such that my Fourth Amendment rights in Michigan are different than my Fourth Amendment rights might be in Ohio, because maybe Ohio has repealed the law of trespass. Maybe that's not a crime in Ohio, I don't know.
Jones said there had to be a trespass combined with a search.
But did it say a trespass as defined by New York law? I think that took place in New York, I could be wrong. Could be DC,
No,
I
they
don't
say
care.
Maryland actually was where the device was
Okay,
installed.
as
instead of
defined
the
by
District of
Maryland
Columbia.
law.
If there was a trespass on chattels, as the court found, does,
Look,
Let's assume we think that your clients were searching for something. They were searching, the police officers were searching for something. They were searching for their clients. That's what they were searching for. Just assume that just for a second, because I want to get back to your consent argument, which I think that's what we were trying to focus on.
Yeah.
So you believe there's a difference between coming in the house and being on the curtilage in terms
Yes.
of how we evaluate the consent. Is it your view that there is no reason for us to engage in an attenuation consideration if they've only entered the curtilage illegally and not the house illegally? That we just start from scratch and look at the consent and see if it was valid? Is there any need for us to evaluate attenuation?
if there is a
Alexa, Siri thinks I'm talking to her.
improper
I'm gonna fine you.
entry onto the curtilage, but the trial court finds that in the totality of the circumstances, the consent was freely
I'm just
given.
asking you to go with me, just
I guess if your question is, does the court need to take that into account in its totality of the circumstances evaluation of whether the consent was voluntary? Is that what your question is?
My question is, in every other Fourth Amendment context I know of, we look at, Wong Sung and Brown, and we decide whether the fruits are poisoned by the illegal search. And if we think there was an illegal search to begin with, do we have to consider that in figuring out whether the consent is valid? Because I understood your position to be from your brief, tell me if I'm wrong, that we just approach the consent kind of fresh because it's separate and apart from the illegal search.
I think that is correct, and to the extent that there is an entry at a 4 o'clock or 5:30 in the morning hour, that is one of the factors that the trial court should consider in its totality of the circumstances evaluation.
So if I get pulled over by the police for no reason, they testify at the hearing, we just didn't like her car and we thought it was her driving it, so we pulled it over and then we reached in through the window and grabbed her purse and started searching through it. And then we said to her, hey, we're going to look in your wallet, okay? And I said, okay. Is that the same as if they had validly pulled me over and then asked, because I had a broken taillight, and then asked permission to search my purse, and I said yes? Are those two just the same? Is my consent in both cases the same?
Your consent would not be, if a trial court, after hearing your description and the officer's description.
Please, just answer her question.
I think I'm trying to, Justice Young. The issue is, is it a factor to be considered by the trial court? Yes. Is it a dispositive factor that precludes consent from being granted? No.
Let me restate it so you can not dodge it. She's pulled over without probable cause. They reach in, they take her purse, and before they look in her wallet, they ask her, oh, by the way, can we look in your wallet? She says, sure. Now, if there's illegal contraband in her wallet, isn't that banned as a fruit of an illegal search? Answer, yes or no.
Yes, based on previous case law, which says that an earlier illegal search.
Well, at least we got an answer. Okay. Now,
taints
how is that
consent.
different from officers going where they have no legal right to be, and then asking for consent to search?
It is, if I could distinguish Justice McCormick's example slightly to try to make it more.
I guess you have to.
If instead of they've reached in and grabbed the person, already started looking through it, they pulled her over improperly. For whatever reason, they just decided we're going to pull this car over. They get up to the door and they say, hey, we'd like to search through your purse. And she says, I got nothing to hide, go ahead. And she doesn't remember that there was contraband that then gets seized and used against her.
And under conventional analysis, is that search and is that seizure considered, is the seizure considered fruit of that illegal stop?
I don't believe it is.
Really?
I don't believe that the...
Why? I thought that was just basic fruits doctrine.
It might. The difficulty is I'm trying to put the hypothetical into, in this case...
No, just answer the hypothetical that was about the car. Illegal stop. I have no probable cause. There's no possible reason. I just pulled you over. And so now that's an illegal stop, and now we're going to roll down the window. May I search your purse? Yes.
Consent vitiates the illegal stop. Converts what would otherwise be
if it
an
is
illegal search
voluntarily
into a legal
given,
search.
as found by a trial court, yes.
Okay.
Okay.
Got your answer?
And in this case, since the defense didn't raise the voluntariness of the consent in their application to this court prior to remand, or in the Court of Appeals on remand, or in this court on its subsequent application, that's part of the reason I have a difficulty addressing that issue, is it's not, I don't believe, right for this court to
Can I ask what I think is a straightforward question? I hope you agree. But whether consent is viewed as an intervening factor, an attenuating factor, or simply a separate factor, in assessing the voluntariness of consent, given at 4 o'clock in the morning in the context of a trespass, do we apply a different standard of voluntariness than in assessing a consent given in the context of a non-trespass at 4 o'clock in the afternoon?
No, this
same
court in the
standard.
U.S. Supreme Court has already said it's a totality of the
The
circumstances.
same
evaluation.
voluntariness standard.
It would be one of the factors to be considered in whether the consent was given voluntarily, but it's a totality of the circumstances test, and it would be the same one as opposed to trying to come up with separate ones for each one or a bright line rule. The U.S. Supreme Court and this court's decisions have said
Are there any
So,
further?
one factor to be
yeah,
considered.
just one more, well, but your answer that you gave with respect to Justice McCormick's car is different than the answer you would give with respect to Justice McCormick's house. So if you illegally kicked down the door of her house in violation of the Fourth Amendment, you've got no warrant, you've got no probable cause, you've not got no, no exception to the warrant requirement, you kick down the door, she's standing in the living room, and you say, "May I look in your purse now?" And she says, "Yes."
I would be hard-pressed to imagine a circumstance in which a trial court would find that that consent was voluntarily given.
Let's say they did. Okay, so you
And
don't.
it was
so
not-
you don't.
and it was not clearly erroneous.
Forget it. I had a jackbooted thug kicking down her door. You just open the screen door. It's summertime. You just open the screen door, walk into the house. She's standing there. "Oh, hello, lady of the house. May I search your purse?" She says, "Sure. I've got nothing to hide in my purse."
Because the standard is the voluntariness of the consent. I think that it is at least
So so now you've backed off your claim that the illegal trespass into the home completely changes the question.
Could I fathom a circumstance where an illegal entry could be, that subsequent consent could be attenuated from an illegal entry? Could I fathom a circumstance? Yes. Do I think it is likely? No, because of the special protections given to the inside of a house by the Fourth Amendment and by the customs and
I just
practices
thought
of
earlier
our
you were advancing a bright line rule. House, one thing, porch, different thing.
It's pretty close to a bright line rule because I can't fathom a circumstance in which there is an illegal entry that would then lead to a finding that is accurately determining that the consent was freely and voluntarily given when police officers are illegally showing up in your house. Is it possible that, yes, they enter the screen and we determine that that's beyond the curtilage and it's actually in the home? I could fathom a circumstance. That's why it's a totality of the circumstances.
I understand. And your other position is that this whole question about voluntariness of the consent is not properly before this court. Yeah?
Correct.
Okay.
It was not raised on the application or on the subsequent application.
Are there any further questions?
I have a question, and I like to try to narrow it down as it pertains to kind of, if you're looking at this from a citizen's perspective.
And simple. Don't
And
forget
simple. That's my big thing today, is keeping it simple. But I think that's actually kind of important as it pertains to kind of the arguments that have been put, in this case. And I think you've done a great job, because it's hard to be on your feet taking all these questions. And I think you've done a very good job with the questions that have been coming at you. The question I have is, let's go to our scenario here, which is this case. It's 4 a.m. There's headlights that are shining into your house. There's a number of different officers that are now, on the premises. They're wearing tactical gear. They have weapons, and they approach your front door. Do you think that the ordinary citizen in that situation feels that they have an obligation to comply?
The difficulty I have with responding to that, Justice Bernstein, is in this case, first of all, they're not ordinary citizens.
Well, but they kind of are. I mean, they're.
But
But
they
that actually,
know-
we can get into that in a second, because that actually, I think, complicates this even more. I think it makes it harder.
It does, which is why I think this
Harder
is not
for
the
you,
great-
I think, because I think that in the situation was you had a situation where one of the people that was coming outranked them, and because you had a situation, you had a circumstance where the person's concerned about their employment, they had a
So
circumstance.
going to the ordinary person, first of all, the fact that
let's do
they're
that first.
wearing vests is to identify them. The record is clear. These are undercover vice officers who would otherwise be wearing jeans and a flannel shirt.
Right.
The vest is to identify them, so that is actually encouraged, so that you know it's a police officer.
But it's 4 in the morning.
It's 4 in the morning.
And now there's lights in my house.
And I don't know that, I didn't find anywhere on the record to verify that the headlights were shining into the house. There were 4 cars that went up there, but I don't know that the headlights were shining into the house. I don't recall that from the
Are you
testimony.
going to argue trivial things?
Let's just assume that the lights were shining into the house.
Do I think that a person,
Yeah.
when told, you don't have to talk to us, but you may, here's a Miranda form that says you don't have to talk to us, but you may, here's a consent to search form that says you don't have to consent to search, but you may, and can they choose to do that without coercion? Yes.
And you don't, but just so I understand, your premise, because I think this really does have an impact. So your premise on this is that under the current law, and what the people are arguing, is that you could have a situation where law enforcement comes to your home at 4 in the morning. They can come in, sizable numbers. They can come in tactical gear. They can come with weapons. Again, their weapons weren't drawn, but they can come with weapons. And you don't feel that the time, the number, the uniform, all these circumstances for a traditional citizen would create a sense of coercion in a circumstance that that is really this case.
I don't think it's any more coercive than Florida versus Bostic, where 2 armed officers are standing in front of a guy sitting on a bus and say to him, can we search your bag? And he knows he can't leave the bus because he's on the bus to go someplace, and it looks like the bus isn't going to leave until the officers get off the bus. And the U.S. Supreme Court said consent can be given in that case. In the evaluation of the trial court, can they find that consent was given voluntarily? Yes, they can, and yes, it can be done. It's not a per se violation. And I think that the facts here are no worse than that of you walk up and you say, can we speak to you? Your name came up in a criminal investigation, and they say sure.
And so it's your perspective that the premise of the knock and talk isn't really violated here, in the sense that the idea of the knock and talk is that, the police are coming over just like a regular citizen would come over, a regular person would come over, and the time, the location, the numbers, all these scenarios don't kind of create a new scenario where you're basically saying that, that this is now beyond the idea of a casual visit to, have a conversation, which was the premise of knock and talk, to now coming in the middle of night, under this circumstance. You don't feel that this really goes against the spirit of what the knock and talk conceptual creation was.
No, because the knock and talk is based on most cases that discuss knock and talk about it in the context of they're there usually to speak to the occupant and to ask them questions about an incident and or to seek consent to search.
Okay, I just want to, and you don't think that this is like any kind of an overreach by government in terms of the conceptual notion of what a knock and talk was supposed to be, to the idea of casual conversation, just what a regular citizen would do, to now being able to come at all hours of the night, fully deployed with uniform, with weapons. You don't feel that that's really in any way an extension of the idea of what the knock and talk was?
Not on these facts where it's clear they were following from house to house to house, following lead to lead to lead. I don't think it's any different whether the information about the drugs or the robbery or whatever comes at 1 o'clock in the afternoon or 1 o'clock in the morning. They're following through on it as the evidence is here. Then I don't think that there's any problem with them knocking on the door. And given the Florida versus Bostic reasonable innocent person standard, had they gone to Mr. Van Doorne's house and knocked on the door and he said, yeah, they tried to deliver me 2 pounds of marijuana butter, and I found that butter wasn't proper, so I told them to go away. I never took possession of it. Would he have preferred them to do that than to go get a warrant? Would he have consented to that ex ante? And I think he would have. I think a reasonable innocent person would have said, I would rather them not put my name to the media, not go through all the hassle of that, not do a search warrant. If I can clear it up with a quick answer to a question, then that's what I would prefer, as opposed to a search warrant with guns drawn and the general protocol that goes with the search warrant. And if I can keep it quiet, because that's a concern, a legitimate concern for somebody who's in their position.
So is it kind of your contention then that this is that this was done as a favor, as a benefit to the citizenry to?
The testimony was that this was intended to be a less intrusive method that was done to partially protect.
No, I understand, but I understand the testimony is. So is it your contention that this type of an approach is actually of benefit to the citizenry?
Yes, because they can say no. They can say, I'm not interested in talking to you at 5 o'clock in the morning. They've been trained on, these particular people have been trained on interviewing techniques, and the fact that you can say, that somebody says no, you have to respect that. As the officers here acknowledged, 80% consent, 20% don't, so sometimes we have to do something else. I think under those facts, what they did here was not a wholesale change of what the knock and talk is designed to be.
Okay, so I just have one last question, but I just want to. Yes, really. You take 20 minutes. I'm going to take 10. I just want to understand the argument, right? I'm not passing judgment. I'm just trying to grasp the argument that you're putting here. The argument that you're putting here is that ultimately, under the facts of this case, I understand the testimony, but is it the people's contention that ultimately that what was done in this situation could ultimately deemed as a favor to the citizen?
Yes, I think that not only was the testimony, I think that under the practice of how a search warrant is typically executed, where the testimony was everyone over 16 is handcuffed and guns are drawn to clear the house initially, as opposed to let's knock on the door, if they consent, hey, we can do this, guns are never drawn, nobody's ever handcuffed. That does seem to me like if I was a citizen being asked what I would prefer the knock and talk.
Okay, thank you.
Okay, thank you, Counsel. This case is submitted. Thank you.